Well, tonight, a Texas judge has sided with a woman who sued to get an abortion for her high-risk pregnancy. Kate Cox, who is 20 weeks pregnant, filed a lawsuit this very week saying that her unborn baby has a genetic condition and carrying the child to term could threaten her own life. Cox's fetus was diagnosed with what's called trisomy 18, a chromosomal anomaly that typically is fatal before or soon after birth. Now, the Texas AG, Ken Paxton, is now threatening legal consequences for any doctor involved in providing the abortion if Mrs. Cox goes forward with it. He claims that she failed to show that she qualifies for the quote-unquote medical emergency exception to the state's strict abortion ban after 6 weeks of pregnancy. Now, the law defines a medical emergency as a life-threatening physical condition aggravated by, caused by, or arising from a pregnancy that, as certified by a physician, places the woman in danger of death or a serious risk of substantial impairment of a major bodily function unless an abortion is performed. I want to bring in Judge Cordell, who is a retired California Superior Court judge. Judge, thank you so much for being here this evening. When we hear stories like this, in many ways, it was contemplated right after the Dobbs decision and even before what might ultimately happen. And the number one thing people point at is this idea of the definition of a medical emergency. Who gets to decide that and who should it be? Here, it's a judge making the decisions, not just the doctor or the woman. Is that what ought to happen here?
Well, first of all, these kinds of issues, I think, shouldn't even be in the courts. It should be between the woman and her physician, but that is not the case in Texas and many other states. So it becomes a question of fact. Here, Ms. Cox came to court and said, will you please restrain the state of Texas from banning an abortion for me? This is a very narrowly focused case. And so the judge did what judges are supposed to do. The judge held an evidentiary hearing on this request for a restraining order. And the state's attorney, the attorney general, had an opportunity and did present evidence. And Ms. Cox presented the testimony of her own physician who gave a medical evaluation saying that this indeed should be a medical exception because her life is at stake, literally life and death. So what the judge did was consider everything and came to a conclusion based on the facts and the law. And as a result said, the state of Texas in this narrow instance should be restrained from keeping her from getting an abortion. And I will tell you, Laura, that the most outrageous thing about this hearing, and you mentioned it very briefly, you have two key players here, Judge Gamble, who I've found to be quite courageous, and Mr. Paxton, who I found to be entirely egregious. The judge made a valid order, and that order is valid because it has not been overturned or reversed by an appellate court. And even though the judge issued a valid order, this man, Mr. Paxton, threatened and continues to threaten to prosecute anybody who follows the judge's order. The doctor, it could be the person who drives her to the hospital to have the procedure. He is basically threatening everyone. In my view, this is obstruction. It amounts to obstruction for which he should be held accountable. This man needs to be disciplined immediately for standing in the way of implementing the judge's order.
It's such a methodical approach you've taken, and just looking at it, if there were a different order about a non-controversial topic, the idea that a judge's order would not be followed for so many would seem egregious on its face, but yet you enter into the controversy of abortion itself and the terminology of how one comes to this conclusion. Judge, I want to focus on the vagueness for a judge to look at this statute that talks about medical emergencies. You say the testimony of her own doctor came in. You are a lawyer, you are a judge, you are not, I'm assuming, somebody who is a medical doctor as well, who's relying on that aspect of your career. Right. The vagueness of that term presents a lot of problems. Is it to deter those from even endeavoring to try, or is it supposed to be broad enough to enable more medical emergencies to be found?
Well, I think, first of all, that this legislation and the definition of medical emergency in Texas, it was done by people who were inept. They were in a rush to do what they could to control women's bodies and came up with this language. So the judge, given this language, it is the law, has to do her best to interpret that law. And she did. And we know she did her best because she issued findings. She made findings of fact. There's no jury here. So the judge is both the jury as well. Did made facts and said, okay, these are the facts. This is who I believe. And then said, I will apply the law to this. Now, there may be an instance in Texas where it's going to go up on appeal in terms of getting more clarity on what medical emergency means. But I really think the language is not that vague. I think the judge found correctly that Ms. Cox fits that definition. Her life is at stake. And also, as the judge made a finding, the possibility of her again being able to have children is jeopardized if she is not permitted to go forward with the abortion. And for Mr. Paxton and others who claim that they are pro-life, then why are they standing in the way of this woman who may not be able to give life again as a result of not being able to get an abortion?
So thought-provoking to think about this. And Judge, one of the main issues I see is that you'll have people who will say two things. One, well, she should just go out of the state then if she has an issue with this, but she wants medical care in her own state, number one. And number two, this is just one person. You cannot decide issues like this, I would assume, on a case-by-case basis and be able to have a universal standard applied. Really important conversation with you tonight, Your Honor. Thank you so much.
Sure. Thank you.